Hobbema, elders and chiefs took Treaty 6 to the UN for them to declare the status of Treaty 6. And under international treaty law, the UN declared Treaty 6 being an international treaty. That makes treaties 1 to 11 international treaties. Treaties signed before and made before Confederacy are international treaties. The Douglas Treaty on the island in BC is an international treaty, much different from the modern day treaties that are being made today. So the UN said, we're going to do something else. We're going to see what the Crown and the British Parliament did to breach Treaty 6. So they examined the Natural Resources Transfer Agreement of 1930, and they declared it invalid. And it's illegal because Parliament and the Crown did not have the consent from the Indian nations that they made the international treaties with, including Treaty Number 6. But here we are still applying and using that NRTA agreement through the feds and the province. And one of the things that the NRTA agreement does in the prairies, it mandates the federal government to transfer title to provincial governments. Now, that's not legal. Like I said, the UN has declared the NRTA agreement of 1930 illegal and not valid. So that's just one example of how our treaties are being violated. And there's many more today. But I've given you now the effects of inherent rights and title, inherent sovereignty, the inherent rights by sector, and how they're linked to the international treaties and the treaty rights that we have today. Now, when you combine those for implementation, how do you implement the inherent right to education and the treaty right to education? Well, it has to be through a traditional contemporary education system that identifies the total traditional form of education implementing our inherent rights to education. The contemporary education rights guaranteed and recognized by the treaty making and the treaty rights to education. An example, the treaty right to education includes schools to be built in every community when they're ready. That's why we see the new schools that we have now today, and there should be more. But the treaty right also includes the recognition of post-secondary institutions, like the First Nations University of Canada, Saskatchewan Indian Institute of Technology, the Cultural College. And in fact, all your post-secondary institutions across Canada are recognized by treaty making. So that's a responsibility that's there. And the treaty making also includes in treaties the recognition of education rights from early childhood, kindergarten, nursery, to grade 12. Those rights are all recognized by education rights and inherent rights. So I'm talking about inherent rights to education, the treaty rights to education. Now, the dispute came about a few years ago. Treaties don't recognize post-secondary ed. Well, the spirit and intent of making the treaties with the Crown said that we will teach you the cunning of the white man. And the inherent right and the treaty rights includes the training and education for trades, skills, and professional education. That's all post-secondary education. Now, the whole system for an inherent right and treaty right to education being implemented under our own jurisdiction and laws and our own inherent legal system Our laws will govern the program standards for our inherent right and treaty right to education. We have no laws governing program standards. Neither does the federal government have laws governing their program standards recognizing the inherent right and treaty right to education, yet they're the other party to treaty. So when the UN declared Treaty 6 being an international treaty, they said both parties have to give them legal effect under their jurisdiction and laws of the governments of their nations in order to maintain the international status of a treaty. Now, in a number of treaty areas, we have not done that as governments of our nations, and neither has the Crown, represented by the government of Canada today. When we talk about giving legal effect then to the inherent right and treaty right to education, where is our traditional Contemporary Education Act, occupying the field for education by community, regionally, nationally, internationally? Now, the other code of silence today is that our sovereignty, our inherent rights, treaties and treaty rights are portable. And that's confirmed by the treaty-making process, the national powers of treaty-making, the national powers of governing, and now Section 35, 1 of the Constitution Act of 1982 confirms it. UNDRIP confirms it. So when we look at the portability of our sovereignty, of our inherent rights and title, treaties and treaty rights by community, between communities, and regionally, nationally, internationally, why are we not implementing that? Why isn't that included in your Citizenship Act, recognizing formally the portability of your inherent rights and status? That's being undermined by the devolution processes of the 1969 White Paper, first generation devolution, and the second generation devolution, designed to terminate the special rights and status of Indians. And they said in '69, you can terminate the special rights and status of Indians by amending existing laws or constructing new laws. And they've been in the process of doing that. Bill C-31 now is terminating whole families at a time, not just one Indian at a time. Our Chapmans, our great-grandchildren are losing their status in terms of their special rights and status because they're registered under the Indian Act, Indian recognition at 6-2 with no rights or benefits. The other category for Indians under the Indian Act is recognizing the inherent rights, treaties, and rights and benefits of Indians under the Indian Act. So we got many of our grandchildren, great-grandchildren, who do not have special rights and status recognized under the federal law. So where is our own Citizenship Act and membership codes occupying the field, registering, certifying our own membership, our own families, our communities? So when we move forward on that type of issue then, and look at the portability of our status, we need to put it in law. And that's why we don't have any more status in terms of an on-reserve, off-reserve Indian, and there should be no on-reserve, off-reserve Indian policies. But it's 2024, and we're still using that illegal policy for implementation of the benefits of our people who are off-reserve, that are entitled to the programs and services for their inherent rights, treaties, and treaty rights. We're not even budgeting for them in most cases. We need to budget that process. And I'll come to that in a later video.